Yes, good evening to all the aspirants of the JCJ 2022 main examination. And today is my turn is culpable homicide. Culpable homicide not amount to murder. Culpable homicide amount to murder. So that is that I am going to deal today. And my counterpart also, my another triumvirate one of he will deal about the private defense today. I believe that Kolikanda, are you present?
Yes, sir.
Good, good.
I have also sent something to you.
Yes, I already did it and I already put it on the screen. And I already prepared also for you this thing. The good evening to the aspirants of the JCJ 2022 main exam TS private defense related to the body under the Indian Penal Code. So that was that thing which I want to make it out. And today I invited one of the guests. If he comes over there, please direct me. And he is Professor Anil Kumar Dikshit. Okay, now let us come to my point. Yes. What is culpable homicide as per the section 299 of IPC? That is the Indian Penal Code. Culpable homicide. It deals about the section 299 of the IPC. Yes, anyone can unmute and read this para, especially participants. I would like to see.
Chapter 16 of Indian Penal Code 1860 deals with the offense against the human body. It covers all the aspects of human life by distinguishing it in different kinds of offenses. One of such offenses is culpable homicide, defined under section 299 of IPC.
Yes. Chapter 16 of the Indian Penal Code 1860. If you are a keen observer, could you write the chapter 16 in that way?
No, it should have been written in
Especially participants. Answer me.
instead of Roman numbers, that is
I
written
said
in
participant, you are a host. Kolikonda.
Yes, sir, of offenses affecting the human body, of offenses.
My question is, could you write the chapter 16 of the Indian Penal Code which I highlighted here?
You have to write, sir.
Is it the right way? Answer yes or no.
Sir, please repeat.
Chapter 16, it is written here. Is it the right way to write?
You have to highlight in Roman letters, sir.
That is the question that I am asked you. And that's my effort. And I already put over here. Let me check where it is. Anyway, that is Roman 16. How do you write the Roman 16? Participants only, not the host.
Capital X and capital V, 1 sir.
Yes, that is the style of 1 is there. 1 becomes 17.
Yes, sir, only 1.
Only 1. So now let us see that what is with the offenses against the human body. Whatever the offenses against the human body, it covers all the aspects of human life by distinguishing it into different kinds of the offenses. When you say the human body, you can say that when an attack will come, battery, offenses of human body. And one of the such offenses is a culpable homicide defined in the section 299 of the IPC. So here what is culpable homicide? We'll see the killing of a human being or taking another person's life is considered the most heinous crime in this world. And this is how the general meaning of the word culpable homicide is derived. To understand this better, let us divide the word culpable homicide into two, culpable and homicide. When you say culpable means blameworthy or holding someone's responsible for something terrible. That is the culpable. Meaning is blameworthy or holding someone responsible for something terrible. And homicide is derived from the Latin word homi, and pseudo. The homi means man and pseudo means to cut. To cut a man. That is the wording. Thus, a homicide means killing of a human being by another human being. Suppose the killing of a human being by a tiger, whether it is a culpable homicide?
No, sir.
It's not even a crime.
It is, he was killed, attacked by a lion, and he was killed. Keeping this meaning in mind, let us discuss culpable homicide as per the Indian Penal Code. First bullet. What is culpable homicide? That it says about the section 299 IPC explain. Essential of the culpable homicide in the same section it is there. And case law related to the culpable homicide and the other provisions. What is that? What is this? Other provisions?
Read with.
Participants should have to say read with. And section 299 IPC. What is the culpable homicide? We will explain it here. So here it says when the death of a person is caused, number one, small bullet, doing such an act which is done with the intention of causing death. See, doing such an act which is done with the intention of the causing death. Intention is present over there to make the causing the death of a person. Or with the intention of causing such a bodily injury as is likely to cause death. Suppose the bodily injury is there and is likely to cause death, then with the knowledge that such an act is likely to cause death, if he is having the knowledge that it will be likely to cause death, the person commits the offense of the culpable homicide. Okay, let me see, before it going on an example, can anyone from the participants say about the one example of the culpable homicide? I repeat the question. From the participant side, I say participants, can anyone give the one example of the culpable homicide? I told you that I am going to deal this thing and you came and editing without reading. No, you cannot get anything. If without reading, if you come and attend my class, and the percentage of grabbing is less. With the reading and participation in the class, and when you participated, the impact is more and directly to go to the memory. At least say pass on so that I could know that you are hearing me. Say pass on. No, we don't want to say pass on. Then
Yes,
give
sir.
the answer. Darlapalli Maunika, are you present?
Yes, sir. I'm present, sir.
Do you want to say pass on?
Yes, sir. Pass on.
And that means you did not read.
No, sir.
Did I inform yesterday?
Yes, sir. You have informed in the group.
Then what is the use of it? See, suppose if you don't know that he is a sugar patient. You know what is a sugar patient is called?
Diabetic patient.
There is another
Yes,
word is
sir.
also there. Can anyone, including the host?
Diabetic.
There is another word is there.
Hypoglycemia.
Yes. That is good. Exactly. Hypo?
Glycemic. Or the disease is hypoglycemia,
Mm-hmm.
and one who suffers is hypoglycemic.
If you a hypoglycemic person, if you make a small incision with a blade, it's enough. He's going to, after the bleeding, he is going to be death. And the death is imminent. Sir, I did not know, sir. I made a small cut to see whether the blade is sharp or not. I did not know that he is suffering with that such a disease. Of course, now people say it is not a disease because it is a common. Diabetic. Whether you know it Either you don't know it. That amounts to culpable homicide not amount to murder, or culpable homicide amount to murder.
Culpable homicide not amounting to murder.
How could you know this one?
Because there is no intention to kill him, sir.
Why you did not give the reply to my question at the time? Sir, I did not get the time, idea at the time. There is no intention to kill him. But subsequently he died because of the profuse bleeding. Because when a person is a diabetic, the blood will not clot so easily. So a diabetic patient, first they will reduce the diabetic percentage, then they do the operation. So here, doing such an act which is done with the intention of causing the death, or with the intention of causing that bodily injury, are likely to cause death, but he doesn't know that because he is a homophilic, he is a diabetic patient. So with the knowledge that such an act likely to cause death, he doesn't have the knowledge because he doesn't know that he is having such a diabetic patient. At the time, we will say it is a culpable homicide, not amount to murder. Then example of the culpable homicide here which is given is X knows Z to be behind the bush. Y does not know it. And X intending to cause or knowing to be likely to cause J's death. Who is having the bad intention?
X.
X is having the bad
X,
intention.
sir.
And Y, and he induces, X induces Y to fire at the bush. Does the Y having any idea that who is behind the bush?
No, sir.
Y doesn't know it. It is clearly mentioned here. And Y fires on the recommendation of X or on the say of X. And who is behind the bush?
Z.
Z. And consequently, what happened?
Z died.
Z was killed. Participants, are you with me?
Yes, sir.
Only Kolikunda
Yes, sir.
Sharad Babu is giving the answer to my question. Here, Y may be guilty of no offense, but X has committed the offense of
Culpable homicide.
culpable homicide. Because he having the intention to kill Z. So here, doing such an act which is done with the intention of causing the death. See, this condition is fulfilled. Am I right?
Culpable homicide is amounting to murder.
Not a murder here. Is it clear?
Yes, sir.
Okay.
Yes, sir. It's
Definition.
almost a murder.
Please, Mamata Kaur, what is your doubt?
It almost up to murder, not murder.
Not amount to murder.
Okay. Okay, sir.
So, essential of the culpable homicide. These are the essential of the culpable homicide as per the section 299 of the IPC. Number one, the death of the person must be caused. Yes, the death of person who Z was there. Two, that the death must be caused by the act of another person who shot at the bush. On the above example, I asked the only participants. In the above example, who shot at the bush?
X.
Why you are not giving the
Why,
answer?
sir?
But why you are taking that
Why,
much
sir?
time?
Why, sir?
The death must be caused by the act of another is the why. The act causing death should have done with either of the following. However, why did it the following? With the intention of causing death. Who? X. With the
X,
intention
sir.
of causing such bodily injury that is likely to cause death. What likely to cause death? When a person shoot at a bush and he knows that, and he encouraged the why to shoot, and why doesn't have the knowledge that X is having the knowledge because either it may kill it or it subsequently to cause the bodily injury that is likely to cause death also. Of course, in the different parts he's made it over there, and the spot it will be operated and the bullet was taken, then he will be survived. Mostly that you could see in the movies. Am I right? Say yes.
Yes, sir.
Yes,
Okay.
sir.
Or with the knowledge that such an act is likely to cause death. So in all the cases, we can say culpable homicide, and it is not a motive murder in other way. Well, now let us see that when it comes to the murder. Case law related to the culpable homicide is, here is the list of the cases law generally read while studying the culpable homicide. Can you read unmute and read the first case law, Virsa Singh case law? Not the same person. I want to hear the other person's tone. Pras, P-R-A-A-S, not triple A-S. I don't know whether such a name is there. P-R-A-A-S, Pras. Unmute and read. Virsa Singh Tesla.
Why the students are not coming forward?
Yeah,
They
I
are
don't know
going
why
to be
they are not.
future judges.
Whether they don't know how to unmute and mute, or they don't want to shy.
After all, it is for them we are holding all this.
Sharath Yadav. Sharath Yadav, are you present? At least say yes. Sir, I don't know how to unmute and mute. Please try to learn from the others. Soundarya. Okay. Anyone? I say anyone.
Visa Singh versus State of Punjab, AIR 1958, SC 465. In this case, the Supreme Court held that there must be a direct consequence of the injuries inflicted on the deceased. Therefore, intervening cause must be independent or unconnected with the injury sustained by the deceased.
So here, the Supreme Court held that there must be a direct consequence of the injuries inflicted on the deceased. At the time, why shooting at the bush? He doesn't know the Z is behind the bush. So he's indirectly, then there is not direct consequence there. Therefore, intervening cause must not be independent or unconnected with the injury sustained by the deceased. So here they made it clear, unconnected with the injury sustained by the deceased. The act would be unconnected, but it is happened over there. At that instance, we will say it will be a culpable homicide. Suppose, okay, now let us see that. On the instigation of X, Y fired at the bush, but Z was adjacent to the bush and there is no injury to him. Whether X has committed any offense at the time? Z was not injured. Who was behind the bush?
Attempt to murder.
It is an attempt to murder. Who? X, but not the Y. Am I right?
Yes, sir.
Yes, sir.
So intervening
Yes, sir.
causes also sometimes make it out either to be culpable homicide or attempt to murder. Joginder Singh versus State of Punjab, All India Reporter, 1979 year, Supreme Court, and page number 1876. The Supreme Court held there has to be approximate causal link between the two, that is a death and the act. A close relation should be there. Death and the act. Act of attacking, and consequently he will be died. The death must be a direct consequence of such an act. And if such a thing would be there, then definitely we can say it is a culpable homicide, or we can also say culpable homicide amount to murder. depending upon the circumstances, how the attack would be there. Nanku versus State of Punjab, the Supreme Court held that as a general rule, a man is presumed to intended the necessary or the natural or probable consequences of this act. Therefore, when a person does an act, it is assumed that he must be aware of the consequences. Of course, the consequences you should have an idea. Either death may cause or death may not be caused, but still he will be charged under the culpable homicide. Section 299 of the IPC. Okay, now let us see what is the other provisions read with the Section 299 IPC. The following provisions are read with the Section 299 IPC, that is Section 301, 304, 308. Now let us see that how the 301 is applicable in the 299. Culpable homicide by causing the death of a person other than the person whose death was intended. Suppose he wants to kill C, but C escaped, D was died. But still, the Section 301 of the Indian Penal Code is better known as transfer of malice. I told you earlier class, a transfer of intention. Is it clear? They want to kill C, but C escaped. But meanwhile, D has come across. And who A instigated, to whom B. And B doesn't have the knowledge. Of course, if there is a bush or any other thing. But if directly A kills him, A wants to kill the C, and the B has emerged over there. Doesn't matter, it's the transfer of malice. In transfer of malice, what would be the offense? How much the punishment? In Section 301 of the IPC covers the ambit area of the culpable homicide in a wider sense. It provides that when a person causes the death of any person whose death he neither intends nor knows to be likely to cause, and he commits an offense of culpable homicide. Let us simply this with the help of example. Read. Anyone can unmute and read. Saundarya, are you present? Sharat Yadav, are you present? Nayak, are you present? Why? These people are just silent. Okay, Mamta Kaur, read.
Section 301 IPC covers the ambit. Okay. Example, how to read, sir?
Over.
No, sir. Example, I have to read or 301?
Example.
Only. Okay.
Example, with an intention to kill
A
B
with
shoots
an
with a
intention.
gun at a B, but it takes C, who is
Okay,
standing
Sharat Yadav
nearby.
is reading
In
now.
such a case,
Yeah.
Let him read the Sharat Yadav.
Okay, sir. Okay.
yeah, A would be the held liable to kill C under Section 301 IPC of IPC, even if he had no intention or knowledge to kill C, and thus this is transfer of malice that shifted from B to C.
So A with an intention to kill B, okay, shoots with a gun at B, but it hits because B escaped and he are lowered down his head. So behind B there is a C and the C hits C, who was standing nearby. In such a case, A would be held liable to kill C under the Section 301 IPC if when he had no intention or knowledge to kill C, but that is the transfer of malice or transfer of intention that shifted from Sharat Yadav, shifted from Sharat Yadav from B to C. Okay, that is a transfer intention. It's a 301. An example, X knows Y and Z are hiding behind the bush. Who knows? X knows. Who are behind the bush? Y and Z. And now X fires with a gun with the intention of killing Y. But it kills Z. Here, X is liable under his section due to transfer of malice to Z. Now, question comes over there. And X knows there is only one person, Y, behind the bush. And he kills at the bush. And the Y was killed. Can you say it the culpable homicide?
It is murder.
It is a pure, no. Culpable homicide amount to murder. That is the answer it will be given over there. हाँ? मैं 8 बजे तक आ जाता हूँ, 8:15 तक. Okay? आता हूँ. Yeah, yes. So now, excuse me. So after this class, I have to go somewhere. Okay, that's no reason. So here, it is very much clearly made that he shoot at the Y and he shot at him and he knows that only Y is there behind. And it is a culpable homicide, amount to murder, we can say there. Okay, now let us see 304. What it says. Punishment for the culpable homicide not amounting to murder. So we can simply say that it provides the punishment for the culpable homicide. The punishment for the culpable homicide has two dimensions, which are of the culpable homicide is caused with the intention or with knowledge. So if caused with the intention, the imprisonment for life or imprisonment for either description, which may extend it to the 10 years and shall also be liable to fine. So that is the punishment. If caused with the knowledge, the imprisonment for either description, which may extend to 10 years or with fine or both. Sir, with the intention or with the knowledge? Both are the same.
With intention means different.
But what is the punishment here?
Life.
Punishment
Here,
is same for
which may
the
extend to 10 years or with the fine or with the both. Either you have the intention or you have the knowledge.
both punishment is same.
Punishment is the same. So let us see the section 308, attempt to commit a culpable homicide. And whoever attempts to commit a culpable homicide shall be punished with the imprisonment of either description, which may extend to 3 years or with a fine or with both. But there, 10 years and here only the 3 years. So this is the actually the thing which I want to make it out. I did not touch culpable homicide amount to murder today. Okay, Kolikanda.
Okay, sir.
Yes, you are right.
I'm going to deal with of the right of private defense in IPC. Sections, which sections deal with the right of private defense participants?
Participants already did the MCQ.
76 to 106, sir. Sections.
76 to 106, sir.
It is from 96 to 106. These sections of IPC deal with private defense. So the private defense is not defined, however, but section 96 says nothing is an offense which is done in the exercise of the right of private defense. So nothing is an offense if it is for self-defense or if it is for the property defense of a person. The privilege of private defense is a significant right and it is essentially preventive in nature and not punitive. So it is meant for prevention and not for punitive means it is not for punishment. It is accessible even with hostility when the state help isn't accessible. For example, the authorities, the government authorities are not readily available, not accessible, not able to come to the rescue, then this right of private defense can be taken. It simply shows that nothing is an offense which was done in the right of private defense. I have already told you. Section 97 is bestowed with the subject matter of private defense. which contains the right to secure the body or property of the people practicing the right or of some other individual. So it applies to both body, both life and property also, both for the person and movable or immovable property. And to protect the other individual also, this private right of private defense can be applied. The privilege may be practiced against all offenses influencing human body or endeavor or sensible danger if the commission of any such offense or offense of burglary, theft, mischief, or criminal trespass and endeavors to carry out any of such offenses in connection to the property. So when can a person take the private defense that is explained here? It may be practiced against offenses, or if the sense is there that the offense may be committed by someone, the offender, like the offenses of burglary, forcibly coming into the house and stealing the things, or simple theft, or any mischief, or any criminal trespass. Criminal trespass should be to the house, not to the outside. And at that instance, that this private defense can be taken, and it applies to property also. This privilege is accessible for the insurance of one's own body or collection of some other individual or one's property or the property of some other individual in the face of animosity concerning body or property against specified offenses. So it applies to individual or to other individual. So for other individual also, one can go to rescue. Indian law on the right of private defense doesn't necessitate that the defense must be identified with the individual whose body or property is topic of hostility. It offers right to everyone to protect anyone's and everyone's body or property against offenses for which right of defense is given. There is no opportunity to take plan of action to the assurance of the open specialists, and the power utilized isn't more than what is important to ensure the body or property of an individual. So when the authorities are not accessible, the government authorities are not accessible, and a sufficient power should be used. A sufficient force can be used to ensure to protect one's body or one's property. Then this right of private defense can be used. And let us know about the basis of the right of private defense. The right of prevent.
You want to say the cases?
Yes, sir.
The general principle
Yes,
case is here.
in the case of this Darshan Singh versus State of Punjab, the Supreme Court outlined the principles of right of private defense. So, in what circumstances this right of private defense can be pursued? So, this is the famous case law Darshan Singh versus State of Punjab, in which Supreme Court gave some guidelines. The first one is self-defense is the essential human nature and is appropriately perceived by the criminal statute of every single socialized nation. All free, law-based and enlightened nations perceive the privilege of private defense inside certain sensible points of confinement. So this private defense is a natural for everyone. For example, someone is going to hurt, we naturally take self-defense. So all democratic countries, freedom-loving countries have extended this right of private defense through their constitutions and acts. The second one is the privilege of private defense is accessible just to one who is all of a sudden stood up to with the need of turning away a looming peril and not of self-created. So this self-defense should not be self-creative. Suddenly, if he is attacked, suddenly it seems a looming danger, a person can stand up and take the self-defense because there is no time to call the authorities or no time to call anyone. So for a person, it is very much essential. An insignificant sensible misgiving is sufficient to place the privilege of private defense into activity. So some sensible misgiving, apprehension is sufficient to place this privilege of private defense for an individual to jump into activity. At the end of the day, it is not fundamental that there ought to be real commitment of the offense. There need not be any real commitment of the offense. If he sees the danger, if a person sees the danger of the offense also, he can take private defense. It is sufficient if the accuser captured that such an offense is examined and it is probably going to be submitted if the right of private defense is not worked out. If it does not step into private defense, then the offense may be committed. If he perceives that sensation also, he can take the self-defense. The fourth one is the privilege of private defense starts when sensible fear emerges and it is seen with the duration of such fear. So the same is repeated in other way. Fifth one, it is unreasonable to anticipate that an individual under attack should adjust his protection bit by bit with an arithmetical exactitude. So if a person is under the threat, then he should take steps step by step. Then it is not enough for him to protect himself. So he has to take action at a time. That is the concept of self-defense. In private defense, the power utilized by the accused should not be completely unbalanced or a lot of more prominent than would normally or appropriate for the security of the individual or property. Here, the force used by the individual to protect the body or the property should be reasonable and should be balanced and not unbalanced. And the proportionate force should be used, not more than that. For example, if he sees a thief, then he cannot shot him immediately. There must be some sensible danger, which is the life threat for the individual. It is all, seventh one, it is all around settled that regardless of whether the accused doesn't argue self-defense, it is available to consider such a request if the equivalent emerges from the material on record. So the accused need not argue much on behalf of self-defense, why he took the self-defense, all these things he need not explain to the court, but the circumstances that are placed on record can give valuable insight to the court or to the presiding officer whether the person has taken self-defense reasonably or not. He will decide. Next, eighth one, the accused need not demonstrate the presence for the privilege of private defense past a sensible apprehension. So the same seventh one concept is again repeated here in the eighth also. Ninth one, the Indian Penal Code gives the privilege of private defense only when that unlawful or illegitimate act is an offense. So according to IPC, if that act is illegitimate or an offense only, then the person can take the right of private defense, the privilege of private defense. 10th one, an individual who is in imminent and sensible peril or danger of losing his life or appendage may exercise self-protection. So for an individual, if he sees danger, imminent, immediate danger, and immediate peril or danger, then he can take the private protection, that is private defense of the body or private defense of the property. Stretching on to death on his aggressor either when the assault is endeavored or straightforwardly compromised. Sometimes if he sees the death, then it may extend to killing that person, the offender also. Right of the private defense essentially defensive and not a punitive right. So it is a defensive mechanism and not punishment. In the case of State versus Chhatar Singh, Honorable High Court observed the following: self-defense is regarded and perceived as it is a fundamental right of an individual to shield his body, someone else, or property, particularly when the plan of action, open authority is not accessible. So again, the same has been repeated by the Honorable High Court in Chhatar Singh versus State. That is to protect one, to shield one's body, or to shield another person's body, or to protect one's property. This can be used provided the open authorities are available. The open authorities means the police and other law law regulatory bodies. The said right is practiced against the attacker. So this can be practiced against the attacker, the person who offends or who is going to offend. The privilege to the private defense being a protective right is principally intended to be preventive in nature and not punitive. So it's anything but a privilege, animosity, or response or right to rebuff. The burden lies on the charge to demonstrate that he had no opportunity to take the plan of action to open authority before he practiced the right to defend himself or another or property under section 97 of the IPC. So if the court asks, the burden of taking self-defense lies upon the accused, that the person who has taken self-defense, according to 97 of the section 97 of the IPC. The punitive resolution perceives that each individual has a right subject to the limitation contained in section 99 of the IPC to secure his very own body, the body of some other individual against any offense influencing the human body. The individual additionally has right to safeguard the property of that of some other individual against demonstration, which falls under the meaning of burglary, theft, insidiousness, or criminal trespass, or endeavors to carry out burglary, theft, naughtiness, or criminal trespass. Under section 99 IPC states that privilege to private defense is not accessible when there is an ideal opportunity to have a plan of action for insurance from the open position and doesn't stretch out to perpetrating mere mischief than should be expected with the end goal of safeguard. All the principles we to have discussed in the Supreme Court case also are highlighted here. So right to private defense is a defensive right and not a punitive right was observed in the above mentioned case also. So right of private defense not available to aggressors. It is not available to aggressors. And in the case of Kishan versus province of MP, the preeminent court held that the accused who was an attacker was not qualified for the right of private defense. So the attacker himself, the accused was attacker himself. So he has no right of private defense. This was declared in Kishan versus province of MP. And in the case of free fight also, suppose it is the fight between two parties, then there is no defense for this private defense. No right to private defense is available in the case of free fight when both the parties are willingly fighting. Both parties are willingly fighting. They have arranged this fighting to fight with each other. In such case, if anybody is injured also, there is no private defense and it cannot be given as aid to either parties. Right of private defense not available against lawful acts. So for lawful acts, the right of private defense is not applicable. So as to verify the assurance of section 99 of Indian Penal Code, it is basic that the demonstration done or endeavored to be finished by a local official must be. Suppose, for example, an official is acting lawfully, then a person cannot take a private defense in compliance with common decency or in good faith. If the official has acted with common decency or in good faith, then no person can take the private defense, right of private defense. And under color of his office, so if it is officially made, then no one can take the privilege of private defense, though the demonstration may not be strictly justifiable by law. Good faith. If he acted on good faith also, the official acted on good faith also, the right of private defense cannot be applied. Section 52 of the Indian Penal Code characterizes good faith as under. Nothing is said to be done or trusted in accordance with some basic honesty, which is done or accepted without due care and consideration. In Kishanram versus Delhi administration, the Supreme Court held that insusceptibility under Section 99 IPC can be asserted by a local official on the off chance that the demonstration in good faith and under the shade of his office. So in this also, the Kishanram versus Kesharam versus Delhi administration also, the Supreme Court ruled that the official acted lawfully and in the color of his office, so and in good faith, so no privilege for private defense. So color of office is explained here. Under the color of office, that is bona fide accepting that it was public worker's obligation to play out the act, whether he was acting legitimately or unlawfully in the release of duty. That is sufficient. If he is acting on behalf of office, sometimes if he unlawfully acts also, does his duty also, then there is no right for private defense. Unpredictable or distinguished from unlawful acts in the event that what has been done will be done in compliance with common decency under color of his office. So privilege of private defense would emerge. It shows that the act was inside purview and the locale has been practiced sporadically or on deficient grounds. So the act has been done wrongly, however, it may have been done properly. So not strictly justifiable by law. Sometimes an act is not justifiable strictly by law. Section 99 is intended to secure a local official, what's more, confine the measure of resistance which might be offered to him. Section 183 of IPC then again isn't a section. Sir, 183. So the case law is scroll up, sir. The case law is Jogras Mehto versus Emperor. In Patna High Court saw that it has been held in a progression of cases that Section 99 of the IPC applies just where there is a locale to do an act that what has been in certain regards illegitimately worked out. The articulation utilized in this section is strictly justifiable by law. Strictly, which means likely that they are not being purposely embedded by the legislature, shows that the section was not expected to apply to situations where the act was completely unjustified. It doesn't reach out to situations where there is a finished need for jurisdiction.
The 5 minutes left.
The right of private defense against acts of infants, insane, intoxicated persons. So in infancy means very early stage of a child, just 1 or 2 years child. Section 82 incorporates incorporates an act of youngster beneath 7 years old. A 7 years old is considered to be infant. Nothing is an offense which is done by a kid under 7 years old. Assume a youngster beneath 7 years old squeezed the trigger of the weapon and caused the death of his dad. For example, a boy, a kid a kid below 7 years old sometimes takes forcibly the trigger and causes the death of his dad. At that point, the kid won't be at risk. Section 83 incorporates an act of a kid over 7 and under 12 of juvenile comprehension. So above 7 and below 12, but he has comprehensive sense, means he can understand the consequences. Nothing is an offense which is done by youngster over 7 years old and under 12, but he has no sense of comprehension, then he accomplished the adequate development of comprehension to pass judgment on the nature and repercussions of his lead during that event. For example, suppose an offspring of 10 years slaughtered his dad with a firearm in the shadow of youthfulness, he won't be at risk because he has no comprehension on the off chance that he has not accomplished development because he has not matured enough to know the consequences. In Krishan Bhagwan versus State of Bihar, Patna High Court maintained that if a youngster who is accused of an offense during the act has achieved the age of 7 years or at the hour of choice, the kid has accomplished the age of 7 years can be sentenced on the off chance that he has the comprehension and information on the offense submitted by him. Surprisingly, the court has given some punishment to this kid in the case of Krishna Bhagavan versus State of Bihar.
Yes, with this that we will stop today's class because anytime it will be going to be closed, and the Krishna Bhagwan, when he knows that, of course the test would be made. That is a test to know whether the evidence of a child can be taken or not. Could anyone tell me that the test name?
Intelligence test.
There is a test in evidence. I will tell you. No. There is a test. He knows the nature of the offense, and hence, even though he is a less than, and he will be punished. Direct our test. No, double our test. Some test is there.
Yes, yes.
I will tell you that a test. It will be a test would be conducted by the magistrate, by the judge, to evaluate.
Roche test.
Yes, yes.
Or CHT or something like.
Yeah. That your test is there. Now, how do you evaluate the witness and how do you call the judge question witness? Examine the witness, evaluation testimony of the witness, especially the child. In criminal investigation, it will be done. Conducted by the judge to evaluate the child witness. Child witness. It is. Child witness. Died our test, something was there, even I could forget it. A war diet test. Read.
Yes. Wire dye test.
Yes. The test is a precursor to determine the child's maturity and ability to deal with the full potential of a witness to testify before a judge and
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
जय हिंद।